Hello, welcome to the training on Arizona's mandatory reporting laws. My name is Rachel Mitchell. I'm a prosecutor with the Maricopa County Attorney's Office. I've been prosecuting crimes against children for 25 years, and I have taught many times on the mandatory reporting laws. Just last year, the legislature decided to make it mandatory to have a standardized statewide training because some of the training that I've seen is not adequate. So this puts all of the laws requirements in front of you, and I'm going to walk you through what those requirements are. You need to understand that this presentation is not specific legal advice. If you have a specific situation, you need to consult with someone such as a lawyer who represents you or your organization. Also, you should know that when I talk about minors or children in this presentation, I'm talking about people who are under the chronological age of 18. These are our learning objectives for this training. We're going to start by talking about the myths of sexual abuse so that those myths, if you hold them, will not stand in the way of you reporting. We're going to talk about how sex offenders operate. We're going to learn to recognize the 4 types of abuse. We're going to talk about who is a mandatory reporter, and then we're going to tell you how and when to report. So let's start with a quiz. The first question of the quiz is, most victims tell right away or soon after the abuse. True or false? Second question. Most sexual abuse results in some form of physical evidence. Offenders who molest males outside of the home tend to have a lower number of offenses. Offenders hardly ever molest with others present or nearby. And finally, most sex offenders were child victims of sexual abuse. You got your answers? All right, let's go through the questions and the answers. Do most victims tell right after or soon after the abuse? Well, the answer is no. Most victims do not tell right away. In fact, 2/3 of victims of child abuse do not disclose until they are adults. And the third that disclose as children usually do so after a substantial delay. So if a child comes to you and says, this happened 2 years ago, that should not be a reason for you to question the truthfulness of what the child is saying. Now, this is talking about child sexual abuse, but understand that delayed reporting is the rule for any type of abuse or neglect. It's very common for a child to have to get to a certain point where they feel comfortable disclosing. As we say in my work, disclosure is a process, it's not an event. Second question, do most molestations result in some form of physical evidence? Well, if you're to watch some of the shows on TV like CSI, you would think that you can find physical evidence in almost every case. But in child sexual abuse, less than 5% of the cases have definitive medical evidence that something occurred. So the fact that there is no medical finding should not tell you that it did not happen. That's very normal. Likewise, a minor's behavior may or may not change. And if it does change, it may change in a way that surprises you. For example, you might expect a minor's grades to go down if abuse is occurring, but the minor's grades may go up because they're spending more time studying in their room to stay away from the offender. So the absence of those types of symptoms are not proof that it's not happening. How about this question? Do offenders who molest males outside of the home tend to have a lower number of offenses? Well, this is a study done by Dr. Gene Abel of convicted child molesters, and here's what he found out from them. That offenders who molest girls within a family have an average of about 81.3 acts with 1.8 victims. And that small number of victims makes sense because it's within the family. So you have a limited number of people that can be victimized. But offenders who molest boys outside of the family have an astronomically larger number of victims and a lot more acts as well. So people who are molesting boys outside of the family actually are a higher risk to reoffend than those who molest girls within a family. Do offenders molest with others present or nearby? You might look at that and think, well, of course they don't. That would be crazy. But the study shows something very different than that. What the study shows is that a majority of them molested with another child present, and about a fourth of them molested with another adult present. 13.2% molested with both another adult and a child present. And then 63% of the people who had not molested with others present thought that they might have progressed to that point. So what's going on there? Why would a molester have a witness? Well, there's a lot of reasons for that. For example, some of those offenders might have narcissistic tendencies. It may be thrill seeking. It may be the danger adds to the thrill. But it's also a very clever way of grooming a child or setting up an alibi. When I was a young sex crimes prosecutor, I used to think that people who did that were not very sophisticated. But as an experienced sex crimes prosecutor, now what I realize is those people are extremely sophisticated. So think of it this way. The child who's being molested with others in the room, what is that child thinking? The others are here. They must know what's going on. They're not doing anything. So is it okay what's happening? Or is it, if it's not okay, no one's going to help me anyway, so there's no reason for me to tell. The child who's in the room seeing this happen is being groomed. In other words, we'll talk about that in a little bit, what that means, but they're being introduced to sexual activity and it's being normalized for them. The parent who's in the room, if they don't know what's going on, it's still setting up an alibi for the offender because they're going to say to the jury or to others who are involved in the case, why would I do that with another adult in the room? So again, it's a very sophisticated way of offending against a child that you wouldn't expect. What about this? Were most sex offenders victims of child sexual abuse? Well, the answer is no. A lot of people buy into this myth, and I think it's really important to understand that it's just simply not true. One of the things that I've noticed as a prosecutor is that when offenders get arrested or charged with a crime involving a sex crime, they will tell people that they themselves were molested. And what that does is it gets them sympathy because people think, well, of course, this is why he does this or she does this. Remember, offenders can be women. And they may try to get a lesser sentence that way. But what the research shows us is this, that pre-polygraph, 70% of offenders will say, yes, I was sexually victimized as a child. But post-polygraph, we realize that about half of those people are lying about it. What is more prevalent in a sex offender's past is not sexual abuse, but either physical abuse or witnessing domestic violence. Think about it. Think about who models your first relationship to you as a child. Typically, it's your parents. And if you're seeing domestic violence or if you're seeing abuse in the home, you get a skewed view of relationships. You get a skewed view of the power differential. And so that is much more correlated with later sex offending. Now, that's not to say that people who are victims of child abuse, physical abuse, are going to become sex offenders. The vast majority of victims do not become offenders. So this is important to understand because A lot of times victims are very hesitant to come forward because they think that they will be branded, particularly boys, but girl victims as well. Boys will think nobody will want to marry me, nobody will want to have kids with me or trust me around children, but female victims think that as well. And so it's important to understand that victimization as a child does not lead to offender behavior. Offender behavior is caused by a lot of things. So let's talk about the process of victimization. What offenders do in order to, as a prelude to molesting a child. First of all, there's victim selection. If there's one word you need to take away from victim selection, it's vulnerability. Vulnerability comes in many different forms, many different faces. Vulnerability can be a child who is developmentally delayed. It can be a child who has behavioral problems. Maybe a child who uses alcohol or drugs. It can be a child who acts up in class. It can be a child whose parent is inattentive. I've had situations where the child's parent has cancer and so just cannot be fully there for the child. And somebody comes in and invades the family under the guise of helping. So victim selection is really based on vulnerability. A lot of people think that victim selection is based on picking a child that meets their interests, maybe the right age, maybe the right appearance, maybe they like blondes or some other sort of physical feature. And that can be true. But what is more often true is the vulnerability. What you don't want to start thinking is that offenders have a type and that they stick to that type. That's simply not true. Offenders can offend against a wide variety of victims. Molesters can be rapists. Rapists can expose themselves. They can be voyeurs. They can have a number of deviant sexual interests that seem inconsistent with each other. Then the next step is engagement. Engagement, think of that as the breaking down of psychological barriers. So it's the having the close relationship, maybe sharing secrets. Maybe it can be a little bit more aggressive by telling the child that I'm your only friend. It's just you and me against the world type of behavior, so that the child starts to become isolated and connected very closely to that offender. Then there's the grooming. Grooming is the physical breaking down of boundaries. So for example, the typical kind of grooming behavior could include touching, wrestling, tickling, horseplay, those types of things. And I want to be really careful here. Those types of behaviors can be very normal as well. It's okay to hug a child. That doesn't mean everybody's going to think that something's going to happen. But what you have to look at is, in a school setting, just common sense types of things. Why is the person hugging the child? Does the child want a hug? Did the child initiate the hug? Does the child seem uncomfortable with the hug? What kind of hug was it? Was it too long? Was it too close? So just common sense types of things. And that leads us to why it's so important for each school to have a policy. Because the policy can address things that the criminal law cannot. And the policy can say, these are boundaries that you need to keep with children. It can describe things like there shouldn't be horseplay or wrestling. You shouldn't have sleepovers at your house if you're a teacher with kids that are not your own kids. And the purpose of those types of boundaries allow your organization to intervene earlier in the process. So, for example, if you have a normal person who really intends no harm, but they're violating some common boundaries, that policy can come in and say, you need to stop that behavior. What's a normal person going to do? They're going to stop that behavior. But if somebody persists in violating boundaries, then that's a red flag that your organization needs to take very seriously. The next step in the process of victimization is the assault itself. This is the crime. And then that is followed up by suppression and concealment. So let's break those down into two parts and talk about what those are. Concealment means once the abuse has occurred, acting in a way to convince the child not to tell. So an example of concealment would be, if you tell on me, I'm going to go to jail and I'm the breadwinner in the house, so your mom won't be able to afford rent. You'll be out on the street. Or if you tell, you're going to get in trouble. Sometimes the threat can be, if you tell, DPS will be called and take you away. And that is very frightening for a child. It's kind of the old saying, the devil you know is better than the devil you don't know. And so when you're being threatened with being displaced from your family, that can terrify a child, even if that family life is not ideal. So that's concealment. Suppression, on the other hand, is a strategy used against people around the child. It's what it does is it diminishes the child's credibility. So for example, I mentioned earlier a person who had moved in on a family where the parent has cancer and cannot be fully there for the child. So this person then moves in on the family and says, well, I'll take your son to a baseball game. I'll drive your kids to church, whatever type of behavior. And so to the outside world, they look like they're just a great person. And then they'll say things to the outside world like, boy, I really feel sorry for Johnny. You know, his mom's got cancer and I've been trying to help out the family. But I think Johnny's got some real problems. I caught him in a lie. In fact, he's lied to me a couple of times. And so what that offender is doing with that kind of behavior is he's diminishing Johnny's credibility so that if Johnny ever does tell, it's kind of a plan B. Nobody will believe it. One thing you need to know about this process of victimization is the concealment doesn't have to be an overt threat. We always think of it, I think, as somebody saying, you know, I'll hurt you or I'll hurt your family. But the better the offender is at victim selection, looking for vulnerability, engagement, and grooming, the less concealment they have to do because it's built automatically into the process. That's why we fear stranger danger so much, because stranger danger doesn't go through those steps in the same way that a known offender, somebody known to the child, goes through. And so they have to engage in more drastic forms of concealment. But stranger danger is the exception. The rule is an offender that the child knows that person. So now that we've talked about some of the myths so that you're not drawn into a certain perception of what abuse looks like, let's talk about the actual mandatory reporting law in Arizona. And this can be found under the Criminal Code, Title 13, Section 3620. You should also know, as a teacher or school personnel, that there is another mandatory reporting law under the Education Code, and that's under ARS 15514. The laws are very similar in that they provide protection from liability as long as you report in good faith, and it also prohibits retaliation for reporting. The four types of abuse involve sexual abuse, physical abuse, neglect, and emotional abuse. If the mandatory reporter reasonably believes that a minor is or has been the victim of any one of these four things, they're required to report. We're going to define what reasonable belief means, and then we're going to talk about the four different types of abuse. A reasonable belief, as defined by our Arizona Court of Appeals, is if there are any facts from which one could reasonably conclude that a child has been abused, the person knowing those facts is required to report. That's a very low standard. This is a very different standard than, for example, when I go to court and I have to try a case and prove someone's guilt beyond a reasonable doubt. That's really the highest standard that we see in the law. Below that are a number of other standards. So, for example, if you sue somebody for running a red light and hitting you, you have to show that they ran the red light by a preponderance of the evidence. That's 51%. For police to get a search warrant or to arrest someone, they have to have probable cause. Reasonable belief is below that. So again, if there are any facts from which you could reasonably conclude a child's been abused, you have to report. And these facts can come from a third party. So you don't have to personally investigate. If a child comes to you and says, this is going on with this other child, you are required to report. So what is reasonable? That's a standard that's used in the law a lot, but obviously it's kind of hard to define. So here's a really practical way to think about it. If you were put on the stand and you're talking to the jury, and the jury is presumed to be community members that are reasonable, and you were to say to them, I knew all of this information and I didn't report. If you think the reasonable jury would look at you and say, that makes sense, I wouldn't have reported either, then you don't have a reasonable belief. On the other hand, if that reasonable jury would look at you and say, you knew all of that and you didn't report, that's not okay, then you're required to report. One thing that I should point out to you is this, that under the law, if the victim who comes to you is now an adult, so 18 or older, and is reporting abuse that happened when they were a child, the law does not require you to report that. We're going to talk about, however, that just because you're not required to report something doesn't mean you can't report it. And there are many situations where you need to seriously consider reporting that situation, such as if the person who did the abusing still has access to children. You still can report, you're just not required. So there are two primary categories of mandatory reporters. There are people who develop the reasonable belief while they are working as part of their job. And then there are people who develop the reasonable belief at any time. So I like to call those 24/7 reporters. It doesn't matter what they're doing at the time they find out about the abuse, they have to do something. So let's talk about the people who develop the belief based on something that happens while they're working. So that would include school personnel. Notice it doesn't just say teachers. It's all school personnel, even if the victim doesn't attend the same school. So how does that happen? How am I supposed to find out about it in the course of my job if the victim doesn't even go to my school? Well, what if a kid comes up to you and says, my sister, who goes to maybe the junior high school, is being abused by my dad? You have learned about that child's abuse in the course of your job, and you must report. What about a teacher who runs into a child in a grocery store? Clearly, they're not at work. Clearly, they're not finding out about the abuse in the course of their duties. Does the teacher have to report if the child says something in the grocery store? Here's my answer to that. Yes, because who cares how you find out about if a child's being abused? Report. Just because you don't have to report doesn't mean you shouldn't report. It doesn't mean you can't report. It's a child being abused. Report it. If you're a domestic violence victim advocate, and let's say you're working with a spouse who is a victim of domestic violence, and the spouse says, my spouse is also abusing my child, you are required to report. And then there are these categories. Some of these categories, of course, are placed at schools. Nurse, Certainly, behavioral health professional might be at a school, social worker, counselor. These are broad categories. And if in the course of treating a patient, they find out that a child's being abused, they are required to report. Then these are the 24/7 reporters. These are the people where it doesn't matter what they're doing. If they find out about the abuse, they have to report. So that includes a peace officer, an investigator with the Office of Child Welfare, a DCS worker. No matter when they find out, they have to report. A member of the clergy, and that includes priests, it includes pastors, bishops, and Christian Science practitioners. If you are the parent, step-parent, or guardian of the minor that is being abused, you are required to report. And then there's the catch-all category that says any other person who has responsibility for the care or treatment of the minor. Well, what if you're a camp counselor? What if you're a Bible study teacher? Same answer as the grocery store scenario. Who cares? This is a child who's being abused. They're telling you about it. You can report, and therefore you should report. So anybody may report as long as you have a reasonable belief. You don't have to be a mandatory reporter. So this is not a must or can't law. This is a must or may law. And you don't have to investigate. In fact, please don't investigate. This is what our Arizona Court of Appeals said. We don't believe that our legislature intended persons with knowledge of alleged child abuse to conduct their own investigation. This, in fact, is one of the ways that schools, churches, and other organizations get themselves in a lot of trouble, is they start looking into the allegations. I'll give you an example. A child goes to a teacher and says, my friend's being abused at home. The teacher reports this to the principal. The principal says, let's bring that child in, the one that's being abused at home, and I'm going to talk to that child. Think of a good time that you got called to the principal's office. I can't think of one. And so this child is coming to the principal's office, certainly is a little scared, and now they're being asked about something that they confided in a friend about by a principal that they don't have that much of a relationship with. And then the child says, no, nothing's happening at home. And the principal then decides, well, then I don't have to report. That's what can happen when you start to investigate. If the reporting child, the friend, comes to a teacher and says, Johnny told me he's being abused at home, just report. Leave it up to the professionals to interview that child in a more neutral setting than a school or specifically a principal's office. Now, there's two ways that you can handle cases if you don't have enough information. So for example, in a sexual abuse case, a child usually discloses that. It's not something that's typically observed by school personnel. So the child may come to you and say, my dad touched me last night in my privates. That's enough information right there for you to act on. On the other hand, you have physical abuse, which is often discovered through observation. So the child comes to school and has a black eye, or has a handprint on his or her face, or winces when the child is sitting down. In that situation with physical abuse, it's okay to ask what we call the 4 questions. Who, what, when, and where. So let's talk about those 4 questions. If you see a child that's got a black eye, for example, it's okay to go up to the child and say, hey, what happened to your eye? What? If the child says something that's reasonable, kids do get hurt. I, as a child, got hurt, sometimes in some kind of weird ways, because kids do crazy stuff. They climb trees, they do things that adults don't do. But if the child does disclose, or they tell you a story that just doesn't make sense, then you can report that. If the child does disclose abuse, then you can ask the following 3 questions: who, when, and where. The who obviously is to identify the perpetrator. The when identifies how recently was this, especially in a situation where we might need to get medical help for the child. And the where helps us identify what police agency to call. So those are the 4 questions. Now, to whom do you report? Well, the law says you can report to either law enforcement or DCS if the person, the suspect, has care, custody, or control of the minor. If the person does not have care, custody, or control of the minor, for example, it's a stranger or it's another teacher, DCS does not have jurisdiction over that case. Only law enforcement does. So in those situations where the suspect doesn't have care, custody, or control, you can call just law enforcement. But let me give you a familiar scenario that we see. The child says, I'm being abused physically, sexually by a sibling. Now that sibling does not have care, custody, or control of the minor. So DCS seemingly doesn't have jurisdiction. But what if the parents are aware of that abuse and are doing nothing to stop it? Then it does become the jurisdiction of DCS. When you call then to report it to DCS, you need to explain this to the hotline. You need to say, this child's being abused by their sibling. The parents know about that, and they're not doing anything to protect. That will get DCS involved. But again, when you have to report to law enforcement or DCS, you only have to report to one, but we recommend that you report to both. Why? Well, law enforcement is primarily focused on the offender, the person who's doing the abuse. But DCS has a different role. DCS has the role of determining the safety of the child and the safe placement of the child. So while they work together, they have different goals. They are mandatory cross reporters to each other. So law enforcement has to inform DCS and vice versa. But it's better if they get the information as soon as possible. And so that's why we would encourage you to report it to both entities. How do you report? Well, when you're reporting to law enforcement, you need to call the police in the city or town where the crime occurred. Usually you'll know this, but there are times when you may not know this. So if you're not sure where it occurred or what agency to call, just call the police in the city where you're at, where you got the disclosure, and they can help you figure out who needs to be contacted. If the crime happens in an unincorporated area, so something that's not an incorporated city, call the sheriff's office. And these are the numbers for DCS, 1-888-SOS-CHILD. Now, sometimes people have a hard time deciding whether they need to report or not, and that's okay. This is not something, hopefully, that happens very often to you, and so it's kind of a foreign experience. And so what we've done with this training is we've put up an additional number. Now, this number, calling this number, does not satisfy the reporting requirements, but it is a hotline that is staffed 24/7, 365 days a year. And that's the Child Help Hotline, 1-800-4-A-CHILD. So if you're on the fence and you just don't know, is this something I should report or not? Call the Child Help Hotline, and a professional there will help you decide whether you need to report and how to do it. The law says that you have to report immediately. And that is something that can occur telephonically or electronically. The reason it needs to be immediately is because, for example, if you're a teacher and that child reports to you, if you don't report it immediately, that child's going to go home to that abuser. Abusers have an uncanny way of knowing something's wrong with the child because they're alert, they're worried about being discovered. What happens if you have not reported immediately? That child goes home and that abuser figures out that something has gone on. That child is now in danger. So you need to report immediately. If it's at the end of the school day and the parents are coming to pick up the child, you need to get on the phone with the police and you need to say, the school day is ending, the parents are here or the parents are on their way, you need to hurry. Do not notify the parents yourself. Let law enforcement or DCS do that. If you're not a mandatory reporter, then you're a discretionary reporter. You're a may report. And because you don't have to report, there's no deadline. But again, why wait? If a child's being abused and is in danger, why would you wait to report? And here's what you have to disclose. Basic stuff, the names and addresses of the minor and the parents or custodians, the age and nature and extent of the abuse. Again, you should not investigate if you don't have this information, just give the information that you do have. And then any other information you have that you think might be helpful. And that includes past acts of abuse. Now, I've had people ask, well, am I going to get in trouble if I say there was something in the past and I didn't report it? And now I tell them, hey, there was something in the past. And the answer is tell them, no, you're not going to get in trouble. Oftentimes, it takes a few incidents for the person to figure out that something is going on. Let me compare that to domestic violence. You might have a domestic violence victim that you work with who comes in to work one day and has a black eye, and you say, what happened to your eye? And the person gives you an explanation for it that could be true. And then the next week they come in and their arm is in a cast. And soon you start to develop a belief that this is not just an unfortunate person who's having a lot of accidents. This is somebody where something's going on. And so same thing might happen with a child. If you see something suspicious, but there's a viable explanation for it, you may just note it, but not report it. But then it happens again. The police and DCS need to know about that prior incident. Failure to report is a crime in Arizona. We take it very seriously. This is not a law trying to get people in trouble, though. This is a law that just is simply trying to get people to report. So failure to report a sex-related offense is a Class 6 felony. And failure to report the other offenses, emotional abuse, neglect, and child physical abuse, is a Class 1 misdemeanor. The duty to report is a personal responsibility. So you can have a policy, and you should have a policy with your organization that says, if you're a teacher and you find out that a child's being abused, you have to tell the school nurse or the counselor or the principal. And that's fine to have that kind of a policy. But that policy does not trump the law that requires you to report it to the police and or DCS. Also, you should know that reporting it to your supervisor does not relieve you of the responsibility of reporting. So if I'm a teacher and I report it to the principal, now we're both mandatory reporters because we both have reasonable belief that a child's being abused. So in that situation, what should you do? Well, you should probably just call the police together. That way you're both there. You've both reported everything you know, and you're covered. So when you do this, make sure you get a police report number or a DCS intake number. Note that down somewhere. And know this, that reporters are civilly immune, even if the abuse turns out not to be true. I get asked this a lot. Well, what if the child's lying? If the child's lying, but you reported it in good faith, you didn't realize it was false, you weren't reckless about it being false, then you are civilly immune. And that same immunity applies under the mandatory reporting law under the Education Code 15514. There are some exceptions to the mandatory reporting law. Some will cover in more detail than others because they're more applicable to a school setting. This is probably one of the main ones that will apply in a school setting. A report is not required if both parties are 14, 15, 16, or 17. You don't have any evidence that it's non-consensual, and the conduct involves pretty much the typical behaviors that you're going to hear about. Now, I get asked a lot of questions about this exception. Some people will say, well, what if she's 17 and he's 18? Do I have to report? Well, technically under this law, yes, you do. And I'm certainly not going to tell you don't report when the law certainly requires you to report. But keep this in mind, that there are other parts of the law that would prohibit us from even charging a consensual relationship between a 17 and 18-year-old. Sometimes the laws just don't exactly match up. So are you required to report? Yes. Does that mean that law enforcement will investigate or submit charges? No. Even if law enforcement submits charges, does that mean I, as a prosecutor, am going to file charges? No. Just report, follow the law, and let the professionals handle it from there on out. Also keep in mind that a lot of times victims will cover up for their offenders. They've been convinced through the process of victimization, the engagement, and the grooming that they're not being molested, they're in a relationship. And so they will cover up that relationship by saying, oh, my boyfriend did this to me, and that's why I'm pregnant. We had sex. And the boyfriend is actually 27 years old, or the boyfriend is actually dad or mom's boyfriend. So don't just take that at face value, that it was just a same age type of classmate. There are some other exceptions. We're not going to spend a lot of time on this, but certainly in a confessional or spiritual counseling type session at church, that's an exception to reporting. Attorney-client privilege is an exception. Disclosures made in sex offender treatment depends on whether it's court-ordered treatment or not court-ordered treatment, whether it needs to be reported, and whether it can be used in criminal court to prosecute. There's also a playground injury exception, and I put it up here, but we're going to talk about whether that's actually something that would have to be reported without this exception. So it says the minor is an elementary school age child, and it's a physical injury that occurs accidentally during a typical playground activity. And then it's at the school where the minor attends, the parents are told, and it's documented. So that's an exception, but I would actually argue that that would never have to be reported in the first place because that's not abuse. It's an accidental act where the child got injured. So certainly it should be reported to the parents. Certainly it should be documented, but under the law, it was not required to be reported as physical abuse because it wasn't physical abuse. So what is physical abuse? What is child physical abuse? Well, a lot of times when you think of child abuse, you think of somebody hitting a child or spanking a child, something like that. So when it's an intentional act, you think of somebody who willfully, intentionally injures the child, but it's not always an intentional act. It can be a reckless act or a negligent act. So these are some examples. Leaving a child unsupervised who's too young to be alone. That is negligence, but that constitutes child abuse. If somebody is a drug addict and they leave their drugs or needles within a child's reach, for example, they leave needles on a coffee table and this child is a toddler and is pulling him or herself up by touching the top of that table, that's child abuse. Leaving a loaded gun in a child's reach, driving under the influence of either drugs or alcohol with your child in the car or with a child in the car. Allowing a child to live in filthy conditions. This is not talking about people who don't pick the towel up off the bathroom floor. This is not talking about somebody who leaves a pizza box empty on the counter. This is talking about a house that is in such a bad condition that it is imperiling the child's safety, and health. For example, there are animal feces on the floor. There are bugs that are getting into the food. The child is not getting proper medical care and is filthy. Those are situations where you need to consider reporting. If a child is in a person's care or custody, they can't injure the child. No one can injure a child, but those people can't even put the child in a situation where the child's health is endangered. So for example, if mom knows that her boyfriend beats the child and she leaves the child with her boyfriend, she is guilty of child abuse. Or if people are manufacturing drugs in a house, those chemicals that are used to make, for example, methamphetamine are very dangerous. They can be explosive. That alone, even if there is no explosion, even if nothing happens to a child, can be child abuse because the child is in danger. And certainly these types of things constitute child abuse if they are intentionally inflicted. And you notice it's a wide range of things that are listed in the law, from bruises all the way up to subdural hematoma, which is bleeding on the brain. But notice it also includes failure to thrive, malnutrition, and dehydration. What does that mean? That means children are not getting what they need either through water or through food. They are being left alone, and so they're failing to thrive because they're not getting the attention they need. So those are kind of broad categories, but they need to be reported. One thing that I get asked about is spanking a child or corporal punishment of a child illegal in Arizona? And the answer is no, it's not illegal to spank a child under Arizona law. Now, regardless of whether you agree with that or not, that is the state of the law right now. So then when does spanking a child stop being legal corporal punishment and start being a crime? Well, again, you're going to use a reasonableness standard. And so some of the questions you might want to ask yourself is, well, how old is this child? Is this a little baby who's being spanked for crying? That's not appropriate. Little babies cry. That's what they do. It's in their job description. Where is the child hit? Is it on the buttocks or is it on the head? Was there an implement used? Now, using an implement in and of itself doesn't make it illegal, but the type of implement is something that you should factor into your consideration. So for example, a parent who rolls up a magazine and smacks the kid on the buttocks is a very different situation than a parent who takes a light cord and doubles it over and is whipping them up and down the legs, leaving loop marks. Those are very different situations. Those should be reported, of course. That's another issue, is are marks left? Is there lingering pain from the discipline, or what the parent is calling discipline? So those are some things that you have to consider. And again, we've given you a number, if you're on the fence about it, to call the Child Help Hotline to maybe talk it over with them about whether that needs to be reported. But those are some things that you should ask yourself. I also want to point out that if the child has behavioral problems, that fact alone should not stop you from reporting. So the parent is saying it's discipline, but you're looking at it saying, gee, this is not reasonable discipline. But this kid does have behavioral problems. So how do I weigh that? Understand that you might be dealing with a chicken and egg type situation. Sometimes the behavioral problems are not the cause of the discipline. And I'm using discipline only because that's the word that the parent is likely to use. Sometimes the behavioral problems are caused by what the parent is calling discipline. When a child lives in a constant state of upheaval, Maybe their parent's a drug addict. Maybe their parent drinks. They don't know which parent's going to come home. They don't know if they're going to get hit that night. They don't know if they're going to get screamed at that night. They don't know if they're going to get molested that night. When that is constantly on the child's mind, think of what is happening in that child's brain. They are constantly in a fight or flight type of mode. It's releasing chemicals into their brain like adrenaline and other chemicals too that impact a child's behavior. So what you may be seeing in your classroom is a child who's not having a good time focusing. They're having to struggle to focus. They're behaviorally acting out. They may exhibit some signs of attention deficit disorder or something like that. And then you find out that the parent has hit this child. Don't be tempted to share in that parent's frustration and say, well, this kid is really a behavioral problem. So I can understand why a parent might have lost it with this child. Understand that the parent losing it with this child repeatedly can cause those types of behaviors. So again, think of the chicken and the egg type situation. And this leads us to emotional abuse. So emotional abuse is defined in the law as serious emotional damage that's diagnosed by a medical doctor or psychologist. Now, to report this, you don't need that diagnosis to be made. You don't have to go see a doctor and have them diagnose the child. But if you start seeing signs of emotional damage, you see a child who is suffering through severe anxiety or depression, not depression because maybe their pet died or their grandparent died, but just ongoing depression, or they are withdrawn, or they're aggressive, and you suspect that this is due to the parent's emotional abuse, report. Keep in mind that if you're seeing any sort of emotional abuse on the part of the parent, you're probably seeing the tip of the iceberg because the parent is most likely on his or her best behavior in front of you. So the parent that's dragging their child into the class by the arm with disregard for whether it's hurting the child or not, the parent who's calling the child the stupid brat and constantly talking down to the child, those are significant signs. And if they're doing that in front of you, think of what they're doing at home. In talking to hundreds of victims of abuse, as I have over the years, one of the things that is consistent is that the emotional abuse may be the worst part of all, because that's what gets into their head and that forms their own self-talk for the rest of their lives. Let's talk about neglect. Neglect is not providing the basic needs of the child. Those are common sense. So supervision of a child, food, appropriate clothing, shelter, or medical care, and it causes a substantial risk of harm to the child's health or welfare. So examples of that, for example, on supervision, would be a child who's found wandering in the apartment parking lot. There's cars going around, the child is small, so hard to see, and the parent is aware that the child is wandering around, or maybe not aware because the parent is passed out due to drugs or alcohol. And that is neglect. Or the child who's around the pool without supervision, who's too young. So the only exception to this would be if the child has a disability or chronic illness and reasonable services are not available to the child. Otherwise, it is considered neglect. And then we have sexual offenses. Sexual offenses can take a lot of have a lot of different forms to them. For example, it doesn't have to be a sexual offense where the child is actually touched. So if you look at the first bullet point here where it says indecent exposure or public sexual indecency, those are crimes of either exposing oneself to or engaging in a sex act in front of a child. And then, of course, touching the child or having the child touch the perpetrator on the genitals or anus, those are also acts that constitute sexual offenses. Now, just because a child sees a parent naked does not mean that the parent has committed the act of indecent exposure. Many families have that type of situation, and it's perfectly acceptable within the family. One of the things you have to do is look at the reasonableness of it. How old is the child? Same gender as the parent, different gender than the parent? Is it something that alarms the child or not? If the child is not alarmed by it and it's normal for the child, that may not be a situation that you need to report. On the other hand, if the child is uncomfortable with it, if the child is trying to or wanting to have boundaries and the parent is not honoring those boundaries, then it gets into a concerning area. Also keep in mind that offenders oftentimes will, and I'm saying this in quotes, accidentally have a child walk in on him or her while they're showering or using the bathroom or changing, and they'll say, oh my gosh, I forgot to close the door. Or they will accidentally walk in on a child who's doing that and say, oh, sorry, I didn't know you were in here. And it's a more insidious type of grooming where they're getting the child used to that sort of thing, and so that they can move on further from there. So the frequency with which that happens, the child's comfort level, who the person is to the child, all of those things matter, and you have to take all of those into account. So let's talk about the first of these, possessing, exchanging, or producing images of child sexual abuse. These images are often colloquially referred to as child porn, but that kind of minimizes how serious these images are. These are images of a child being sexually abused or exploited. I get a lot of questions from people about, well, what if I take a picture of my child running naked through the house because they're 2 years old and they took their diaper off? That's not child pornography. That's not an image of child sexual abuse. Let me give you an example of a picture that is not child sexual abuse. Most of you, I'm sure, are familiar with the picture of the Vietnamese girl who is fleeing her village after it's been napalmed, and she is completely naked. You can see her entire front of her body. That is not child sexual abuse, a child sexual abuse image. Why? Well, first of all, she's not being sexually abused in that. I mean, horrible things are happening, but she's not being sexually abused in that. And she's not being sexually exploited by the picture. Yes, you can see her genitalia. However, she's not posed. In fact, it's such a moving photo because it's very candid. There's no focus on her genitalia. It is a full body shot. So that's not what we're talking about. When we're talking about images of child sexual abuse, let me just say they will ruin your day. They're horrible. And people who are looking at these have a problem and they are dangerous to children. There is a correlation between possessing images of child sexual abuse and offending on a child, and they need to be reported. Luring a minor for sexual exploitation is typically when somebody contacts a child, oftentimes through a digital medium, and asks the child to engage in sexual acts with them. Voyeurism is what we used to call peeping Tom, but we now understand is actually a prelude to more serious crimes. And so voyeurism has to be reported. Secretly photographing, videotaping, filming, or digitally recording a minor. Sometimes offenders will hide cameras so that they can get pictures of the child going to the bathroom or showering or changing. If you find out about that, that has to be reported. Child sex trafficking. This is something that has very much come to the forefront of our minds, that children are being sexually trafficked in the United States. And these are not children necessarily that are from another country. They're children that are in our schools and in our neighborhoods. And then finally, female genital mutilation. That was added a few years ago, and of course that pertains to what is colloquially referred to as female circumcision. That has to be reported. So I hope this is giving you a clear view of what the mandatory reporting law is in Arizona. Again, we've given you resources to talk to people if you're not sure. We've given you the numbers to call for DCS, and we've told you what police agency you need to report to. The bottom line is this: you all are in a profession that you entered to help children, and child abuse is a lifelong impact on children. It doesn't mean their lives are ruined, but they certainly are impacted by this, and some lives are ruined. Some children are permanently injured or even killed. So you're on the front lines seeing these children every day. Thank you for what you do. Thank you for taking the time to listen, and please report.